Joining me now, Maya Wiley, civil rights attorney and president and CEO of the Leadership Conference on Civil Rights and Human Rights. Evan Wolfson, founder of Freedom to Marry. And Tona Boyd, associate director counsel at the Legal Defense Fund. This is a fantastic panel. Thank you all very much for coming to the Saturday show. Maya, how dangerous are the precedents set by these cases? What implications do they have for other rights?
They're extremely dangerous. And I keep quoting President Joe Biden because he was right when he said this is not a normal court. We have had decades of making sure we're not only protecting civil rights, we're expanding them appropriately to people who have not been protected. And some of this precedent, this case law that the Supreme Court just batted the back of its hand at in these, both in the affirmative action cases and in 303 Creative, the LGBTQ rights case, is actually saying, look, we're going to open the door both to ignoring the long-standing and still present role that racism is playing in society, including in terms of access to college, higher education. But we're also going to ignore all the progress we have made in saying, if you are a private business, you can't just choose not to serve people because you don't like who they are, who they love. I mean, this is as Justice Sotomayor said in her dissent in 303 Creative, in this website case that wasn't, where the court took a case where a business owner who wasn't even doing the business she was complaining she might have to serve people who are gay or lesbian and may want to get married, something that's now a constitutionally protected right, that she just doesn't want to do it. They actually said that she didn't have to, that it somehow violated her First Amendment rights. Well, that opens the door. While the case did not go that far, while they tried to claim that they were narrowing it, what they really did is create a door that an elephant could walk through to say, you know what? I now, as a business, have a First Amendment, a strong First Amendment right in not serving people I don't like because I don't like who they are. This opinion. And this is how it starts. I just want to remind people of Dobbs, of reversing Roe v. Wade. It started with cases like out of Pennsylvania where the Supreme Court said, oh, we're not getting rid of Roe. We're just saying the state can do all kinds of things to make you jump through hoops to get an abortion, but we're not completely taking it away. And over the years, that became a reversal of Roe. That's what's happening here. That's the way we have to understand it. And we have to get back to being a country that values and protects all our people.
Well, Evan, let me come to you because, Maya brought up the Colorado case, which was built on a hypothetical. I didn't think the Supreme Court or courts in general could take cases built on hypotheticals. Aren't you supposed to be genuinely and directly harmed in order to ask the court for some kind of redress?
Absolutely. It was a bogus, constructed case designed deliberately to get this question in front of these justices who've been installed on the Supreme Court by Donald Trump and Mitch McConnell, packing the court, and to get the result that the proponents wanted, which was to begin eradicating not just protections for LGBT people, but for all Americans, because this case, as Maya rightly said, carves a hole in the edifice of civil rights. It basically invites a carve-out that would, if taken seriously, swallow civil rights. But fortunately, there are things we can do about it.
Meaning, like, other than voting and getting people in elected office who will then appoint judges who could turn things around?
Absolutely. Step one, you have to look at who put these judges on the court, who installed them to deliver on this agenda. But the other thing we can do in addition to that, and that is definitely number one, is structural reform. We need to address the fact that this court has been packed, and as President Biden said, this is not a normal court. And the way we fix that, according to the Constitution, is by expanding the number of justices and allowing a more representative court, more in tune with the values of the American people, and not serving some plutocrat's agenda to rule in a way that will inspire Americans with confidence in our democracy.
Well, speaking of plutocrats, Tona, I'm going to bring you into the conversation, and I just have to say, it is so wonderful to see you. The affirmative action case was brought by a conservative billionaire. The Colorado case, as we've been discussing, was based on a hypothetical. The student loans case was brought by Republican states, not students. So does the court, even accepting these cases, show they are trying to legislate from the bench, which is something I thought conservatives and Republicans thought was verboten?
First of all, I want to thank you, Jonathan, for having me. It's wonderful to see you as well. Listen, it's incredibly troubling what the court has done in these cases. But I think it's important to note what the court actually did and didn't say, I think particularly in the affirmative action context. So the decision is alarming. Look, there's no other way to put it. The court ignored decades of precedent. But I also want to point out sort of what it did not decide in that case. So in the affirmative action decision, the court's decision is really limited to the consideration of race as a tip in college admissions as it applies to the programs at Harvard and UNC. I think that's really important to note because folks are trying to apply this case more broadly than is applicable. And I think given the fact that the court is reaching out to hear these cases in the first place, we've got to put them in the context that those decisions are.